agreement on the child support numbers, the retroactive total. But I believe that we have agreement on geographic restriction, but we do not have agreement on the visitation, Your Honor.
All right, she's for. Well, let me see what these circumstances are. Here's the deal, folks. Under Texas law, the non-custodial party is entitled to a standing possession order. Standing possession orders come into full force effect after the third birthday. This child's over the age of 3. So, what I need to know is the circumstances with as far as visitation and access to the child the father has had, and see whether or not the court should go ahead and start standing visitation day 1 in accordance with the Texas Family Code. And now, folks, I just laid out a lot of legal mumbo jumbo, but the bottom line is that's the standard I'm gonna have to look at. So again, I'll let the state tell me what y'all had in agreement, and see whether or not that the court can go along with any request on the visitation based on what both parties are trying to accomplish. So at this time, I ask you both to raise your right hands and let me get you under oath. All right, do you both solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth to help you?
I do.
I do.
All right, you're both officially under oath. You can put your hands down. I'll let the state call you both as witnesses. And at the end of the hearing, if there's anything either you wish to tell the court, so long as it's relevant, you can tell the court that information. But the court gets to determine what's relevant, because pro se litigants like to go afield sometimes. And right now, the only thing I'm interested in are the 4 corners of your pleadings, and that means conservatorship, child support, visitation. So let's see what we got. And you may proceed with your first witness, Ms. Metzer. Thank you.
Yes, Your Honor. I'll call Tahisha Bryant. Ms. Bryant, will you state your name?
Tahisha and Bryant.
Okay. So we have discussed the numbers before, and we decided that the child support should be calculated at $621 per month starting October the 1st, 2025, correct?
Correct.
And the medical support should be $104 per month starting October 1st, 2025, correct?
Correct.
And dental support should be $4 per month starting October 1st, 2025, correct?
Correct. Yes.
And we calculated the retroactive total to be $12,492 total, right?
Correct.
And the repayment was $112 per month starting October the 1st, 2025.
Guys, this one starts with a heated courtroom setup, where the judge wastes no time laying down the law. He calmly explains how Texas custody and support rules work, making it clear this won't be an easy ride for either side.
Correct.
Correct? Okay. And do you have access to private medical insurance for Azaria?
She gets her medical insurance through me, which is through Scott and White, and it's Cigna.
And that's how we calculated that $108 per month amount, right?
Correct.
And that's just for her, not including you, right? That's how we calculated it.
Yes, the amount that was calculated is just for her.
And then for the dental support, we calculated that by prorating it because 4 people were on your dental insurance, or 5 people were on your dental insurance, right?
Correct.
And so that $4 is just for her, right?
It's just for her.
Okay. And we calculated the retroactive total because you gave him credit for some Cash App payments. Is that correct?
Correct.
Now, as far as the retroactive total, we wanted it to start on your daughter's 2nd birthday. Can you explain why?
For the first 2 years of her life, he was more involved and he was doing more. After that time period, he wasn't. It was harder to get him to provide for her for the things that he needed. It was always, I can't right now, I don't have it right now, or if him and I were not talking at that time, then he absolutely wouldn't do anything for her, because he felt that because he couldn't see her, then she wasn't his responsibility.
Okay. And I'm sorry to switch gears here, but you're in agreement with the geographic restriction to Bell County and contiguous counties, correct?
Correct.
And you do want to communicate with Mr. Noel via app close?
Yes.
Okay, why is that?
because when I don't answer his
Ma'am,
phone
ma'am, ma'am,
calls
here's the deal,
or
ma'am, here's the deal. I'm gonna do that, period, okay? The last litany of information you just went through got you there before you even had to answer that question this time. So I want everybody on App Close, because App Close is a concise documentation device. I hate trying to get information out of text messages, and and that app will, if I need a text, it'll print it out like a book. All right. So okay. And I know it's correct, and it's not been spoofed or created by some type of AI. So yes, ma'am, we're going to use Aptos going forward. So there's no explanations necessary. May proceed
Yes,
to
sir.
okay.
next.
Yes, Your Honor.
Ms. Bexler, thank you.
Yes, Your Honor. Okay. Now, specifically, how do you see visitation going between Azaria and Mr.
Okay, here's the
Noel?
deal. Give me the history of visitation, and we'll take it from there. Okay.
Yes, Your Honor. What is the history of your visitation, Miss Bryant?
The history of visitation is I've always been present when my daughter has been there. Either I've come over and we stayed for a couple of hours, or in the past when we worked together, I would stay the night. That's how visitation has always been. I do not feel comfortable with her being there over the weekend with him because of the people that.
Okay, ma'am, stop. You answer the question. Don't go to the next level.
Okay, I'm sorry.
And what I need to know, when's the last time the father had any kind of access to the child?
About 2 weeks ago.
And what was that visitation like?
It was fine.
I mean, what was it? How long? Where was it? What was the circumstances?
It was at my house, and it was for about 45 minutes.
All right, and time before that?
Probably a week or 2 weeks before then. Same visit at my house for about 45 minutes.
Okay. So, and how long y'all been doing that at your house, at your residence, for 45 minutes to an hour for us? Anytime been at your house, ma'am? How long have y'all been doing that? And give me your best guesstimate on how many visitations he's had this year. Thank you.
Maybe about 6 visits this year.
All right, thank you. You may proceed. You may expand on that question if you need to, Ms. Bexler. Thank you.
Okay. Do you believe that if he has your address or phone number, that you or Azaria would be in danger, physical danger?
No.
So, do you want a supervised visit between Mr. Noel and Azaria?
Yes.
All right, ma'am, why? Why do you think there needs to be supervised visitation going forward?
The
And here's the deal, ma'am. Here's the deal, ma'am. You can testify to anything that you are an eyewitness to or seen, and the more recent, the better. And but you cannot testify to anything a third party told you. But you can testify to anything you've seen and anything that the father has told you. So keep that in mind in your answer, ma'am. Thank you.
Okay. I can testify to the type of people that he's had at his house. The only people, I'm sorry.
And what type of people are those, ma'am? And again, unless you saw them doing something, again, how do you know that the people that you've seen at his residence will somehow be harmful to your child?
I have not seen anyone in the act of doing something wrong or illegal.
Okay.
And you said not to say anything of a third party or anything of what he said.
No, you can testify to anything that the father has told you, but you cannot testify to anything else someone else has told you about, especially another third party.
Okay.
Technically, you can't even testify to anything that a third party told you about the father. So.
Well, from the father's mouth, he have said that some of his friends have gone to jail. He said of some activities that go on in his house.
And what has he told
And
you? What has he actually told you about any activities at his residence, ma'am?
he has a pool room, and they go in there and they smoke and they drink and they do drugs in that room.
Okay, ma'am. He told you he's done drugs.
Yes.
Okay, and when did he tell you that? And what circumstances?
I went over to his house probably about a month ago, and he wasn't acting himself. And I asked him, I said, normally you were a little bit all over the place, but today is a little much. Like, what's going on with you? And he just kept laughing, and he was like, oh, I've just been doing drugs. And I told him, I said, don't play around. That's not funny.
Okay.
And at the moment, I wasn't sure if I should take it seriously or not. But his personality, normally he is a very hyper person.
Here's the deal, ma'am. You can't explain why you did what you did or heard what you heard. You can only testify to what he actually said. Unless you have a PhD in psychology or some type of law enforcement expert on drug use, then ma'am, you can't testify to something like that. Thank you.
Okay.
All right, state may proceed with the next question. All right, I'm sorry,
No,
ma'am. Did
Oh,
he tell
sorry.
you what type of drugs he was on or he was using at on that date?
He said he's been doing coke.
All right, and did he ever tell you that before or since?
I mean, he's told me that he's done it in the past, way before I met him. He said he used to do it.
Okay. All right, you may proceed.
I don't have any further questions, Your Honor.
All right, ma'am, be back in just a moment. Call your next witness, please.
State calls Larry Noel. Larry, can you state your name? Mr. Noel, you've got to unmute yourself.
I apologize, Larry Noel II.
The atmosphere shifts from argument to accountability as everyone realizes the outcome could redefine custody. It's a turning point. Justice now depends on the truth that test reveals.
I'm sorry, what was that you said?
Larry Noel II.
Oh, okay, the second. Okay. Did you apply for services with the Office of the Attorney General?
Yes, I applied. Yes, ma'am.
And you sent me a check stub that says that you make $21.84 per hour and work 40 hours per week, correct?
Yes, ma'am. Yes, ma'am. At
And
Wilson Art.
And
I'm
you've
sorry.
been at this job for the past 4 years, correct?
Yes, ma'am.
And those numbers that I said you're in agreement with, right?
Yes, ma'am. I have no choice. Yes, ma'am.
You do. You do have a choice, but those sound correct, right?
Yes, ma'am.
Okay.
But other than I filed on myself because I've been in my daughter the whole life.
Okay,
and I don't want to go into. I'm sorry, sir.
The same thing I told her. Listen to the question, answer the question, and stop.
Yes, sir. Yes, sir. Apologize, sir.
The state will expand. Don't worry. Thank you.
Yes, sir. No problem.
And if Tyhisha has your address,
Yes.
would you feel in danger?
No, no, no.
And are you willing to communicate with AppClose?
Yes, I don't mind. Yes, that's not a
And
problem.
Are you okay with Bell County and contiguous counties being a geographic restriction for your child's primary residence?
Yes, no problem.
And did you sign off on that acknowledgement of paternity when Azari was born?
Oh, yes, yes, ma'am. Yes.
And we tried to calculate how much you would have to pay for your child, for your health insurance, but it was more than what Miss Bryant pays, correct?
Yes, yes.
Do you have any other children besides Azaria?
Yes, my son. He's 22. He's 22. It's just me and him here. I just bought a house 2 years ago, so it's just me and him.
Okay.
And
And you
my
sent
daughter.
me the Cash App
Go ahead.
receipts, and that's how we
Yes.
got the retroactive total, correct?
Yes, yes. That and it's we were together when I was doing stuff, so I just gave you those receipts. I didn't know to keep receipts. That's why I didn't know. I would have kept receipts. I've been there the whole time. That's why I applied for one myself.
Okay,
And she had, go ahead. I'm sorry.
that's all right. Now, as far as the visits go, how many visits have you made with Azaria?
I haven't, but last week when I seen her, she let me see her. She unblocked me and allowed me to come see her. I just dropped the stuff off on the porch when I come. I can't never, when I go over there, I always been watched by her mom and stuff. I can't never, I don't know. I shouldn't even expand on it. You're right. Maybe like about in the last month, just one time when I just went over there last week.
How often
Yeah,
have you tried to go over there?
Oh, I try to go over there like at least twice a week, once a week. But I never get in. I knock on the door, be standing outside. And I got a big house, 5-bedroom. My daughter got her own room here. That's why I found on myself. And it kind of hurt me because she said I wasn't there and I've been there. But I don't know to keep receipts when I'm for my daughter. So I'm
Okay,
not
so
on drugs. I
okay,
can
okay,
take
so
drug tests if they go ahead. I'm sorry, sir.
all right, yeah, don't jump the subject. Don't worry, we're gonna get
All
ready
right,
to
all right. I'm kind of happy though, man, because I ain't been seeing my daughter. My
okay.
bad.
All right, I don't want the state's not going to ask you any questions technically about being on any type of drug. I'll have to give. I always invoke anyone who's testifying before this court their Fifth Amendment right for them, because anything that can be said here can be used against you one way or the other, either as something you've done, or if you're not telling the court the truth, it could be perjury. So I always automatically invoke the Fifth Amendment right, because you don't have a lawyer here to guide you through the minefield of what could happen. But I've already got something I'm gonna do here on this one, so you don't have to go into. You say you just told the court you do not use drugs. Is that correct, sir? And
No, no way.
You're
Yeah,
willing to pay for a drug test.
yeah, I could take a drug test.
All right, good enough, sir. Because that's what we're gonna do. We're gonna do a temporary order. We're gonna get you tested, and you come back negative. Guess what? You're gonna be on the fast track to seeing your daughter under what the law requires me to do, so, ma'am, sir. And I'll let mom know that too. But you may proceed, Miss Betcha. This is gonna be a temp anyway. All right.
Mr. Noel, do you have anything that you think the judge needs to know about any of this?
No, I'm good. No, I can't wait to see my daughter, start seeing my daughter.
All right, I'll pass the witness, Your Honor.
All right, folks. Again, I'm looking at making this a temporary order. I got 4 levels that I usually use for break-in visits, and the first one of the 4 is with mom being present. But it sounds like y'all may have done that, but it's usually for about it's a 4-hour, not a 45-minute thing. So, and if mom's going to be present, that's fine. She can use a designated agent. She can use her mom if she wants to, but only one of them. They can't both be there ganging up on you, sir. And it's got to be for at least 4 hours. I'm going to appoint, for right now, I'm going to appoint Mr. Kurt Glass as an amicus for the court. If I need to turn him into an attorney ad litem, I will. But what amicus does, he's a lawyer who's going to facilitate what I need to get done here as far as that drug testing is going to be done. And since the only one that's alleged to be done on drugs is the dad, I'm only going to have him tested. And Mr. Glass is going to set that up with any drug test or any test now out of Harker Heights, sir. And for right now, I'm going to do both. I'm going to do a urinalysis and a hair follicle. The urinalysis would only catch cocaine or that type of drug use. Very recently, the hair analysis will catch it as odor. If either come back positive or both come back positive, then obviously I got to deal with it. But if they both come back negative, we're going to go straight into finalized order. If the urinalysis comes back negative, the hair comes back positive, I'm going to set this out set up a temporary package and come back after a couple of months and see if the concentration has gone down. And if it's going down, that shows that you haven't been using it since then. And we'll get you into a package where you're going to be able to work your way up to the standard of getting your daughter under a standard possession order. Like I said, the first 4 levels are the first 4 hours with mom. Then after that 4 hours, you get to pick the child up, serve by yourself, and go off and come back. Then after that, sir, it's 8 hours for visits, and it's usually 3 to 6. Everybody's local, so there'll be 6. The next, after you get it for 4 hours, then you get it for 8 hours. Then you get overnight, and then you do the standard visitation. And at 4 years old, like I said, it's usually 6 visits, but since this child is older, I'm probably looking at doing it at 3 visits each. But for right now, I'm gonna go ahead and look at setting y'all up as temporary joint managed conservators. Do the temporary order as per as everyone's testimony, and then have Mr. Glass set up the drug testing, sir, in Harker Heights. You're probably looking at about right at $400, sir. Can you afford that?
Ooh, I can't even afford that right now.
Here's what I'm gonna do. I'm gonna this is gonna be on my dime, but it's gonna be on your. If it comes back negative, sir, then I'll take care of it. If it comes back positive, you're gonna owe the people, good folks at Bell County, $400 and some change. Understood?
All right, I get back in town tomorrow. Is that cool?
Well, okay. Well, I'm gonna go ahead and have the state contact Mr. Glass, and I'm gonna need both of your permission to have your contact information given to Mr. Glass. Really, technically, it's yours, sir, since he's working for me right now and not for either of y'all. So I'll need your permission to have the state give him your phone number and your email. Is that okay?
Okay, no problem. Yeah, you can call me. Yeah, we can set it up.
All right, and he's gonna set this up. And what's your work schedule, sir? Monday through Friday or what?
Yeah, Monday through Thursday.
Monday through Thursday. Okay, well
Yeah, I took a little vacation. I'll be back tomorrow evening probably.
All right, then. Well, it'll take Mr. Glass a couple of days to get up there because he's got to send in. He's got to request me to pay the funds, so it's going to take to probably sometime next week. But I'm going to go ahead and so he'll probably they're open on Saturdays, so we can do it on Saturdays. If you're off on Fridays, we can set it up on Friday.
Yeah, Saturday will be cool. I can go up there Saturday. Yeah, that'll be perfect.
But it may not be this Saturday, sir. It might not be the next Saturday. We'll wait and see if Mr. Glass can get it set up for this Saturday, and he'll contact you on that. So
Okay, that's cool.
all right, I'm gonna start with you, sir. Questions.
Yeah.
What's your question? The next question, sir.
Excuse me?
You have any questions, sir?
Oh no, I'm happy. No, I'm excited. No, sir.
All right.
Your Honor, Mom disappeared. Oh, there she might be back. There she is.
All right. In the temporary order, I'm looking at first, third, fifth Saturdays of the month. First, third, fifth Saturdays of the month from 1 o'clock in the afternoon to 5 o'clock in the afternoon for the temporary visitation package with the mom being present. And then we'll see what the drug test shows, and then I'll come up with my next order. So at this time, ma'am, do you have any questions? You muted, Ms. Bryant.
Okay,
All right, questions, ma'am.
no questions.
All right, Ms. Bryant, again, he's entitled to certain rights under the Texas Family Code, and I've gotta give him those rights. But I want to find out whether or not he's on any type of drugs at this point, or if the test is positive, and then we'll figure out where we go from there. But for right now, I'm going to go ahead and appoint Mr. Glass as my lawyer, and then I'm going to, if I need to, he may end up being the ad litem for the child, which means I can transfer him over to being the child's lawyer if this thing goes sideways on us. So, because he's already going to be up to speed on what the circumstances are. But right now, he's just going to set the drug test, get that back to me, and we'll see whether or not I need to upgrade him from a amicus to an attorney ad litem represent the child once we get the drug testing back. So, yes, ma'am.
Can the addresses be disclosed, Your Honor?
Well, for right now, the only information needs to be from Dad, and he's given us that information. Ma'am, here's the deal. If I got to make him the attorney for the child, and I'm telling you to remain neutral. Right now, he's neutral. The only thing he's got to do is set up the father's drug test, and I could have him do that as the child's lawyer too. You have any problem with the state giving the attorney your phone number and your email just in case?
No.
All right, then. And again, the temporary visitation is the first, third, and fifth Saturdays of the month from 1 p.m. on Saturday to 5 p.m. on Saturday. All right. So it's not 45 minutes. It's a whole 4 hours. And again, sir, how you say your son is an adult?
He's 22.
All right. You can bring him with you, sir, if you want to. Ma'am, you can have someone else present with you if you want to, but nobody interfere with him actually being with the child during that time frame. Understood?
Thank you. Yeah.
Understood.
Okay.
Are we ordering temporary support, Your Honor?
Oh yeah, we already everything else is a temp. Everything that you just went over, yeah, of course.
But are we going to reserve the retroactive total, Your Honor? for
You can do
later.
that now too. The only thing I'm going to reserve is the visitation. Everything else is going to be final.
Ah, yes, Your Honor.
All right, folks, that's again legal mumbo jumbo. Everything else that y'all just testified to, the child support, the retro, the repayment, all that going forward, after 30 days, that becomes final and cannot be undone. And the only thing I'll hold in advance is dealing with the visitation package that the father will get until we get the drug testing results, sorry.
The judge set strict temporary visitation, making sure the child's safety comes first above all else. Every condition is crystal clear. No loopholes, no second chances.
All right, folks, I'm gonna go ahead and let the state prepare that order, get it to both of y'all. And again, Mr. Glass will be in contact with you, definitely, sir, and ma'am, maybe even with you, okay? And if he
Okay.
calls me and says he prefer to be the ad litem to the child, which means he's the child's lawyer, I will go ahead and make him that. But again, remember, if that's the case, he's her lawyer, not yours, ma'am, not his. He only does what's in his client's best interest. He becomes that, and he'll complete his investigation, and he'll make recommendations and advocate for those recommendations as a lawyer. All right. All right. You understood, Mr. Noel?
No, I'm good. Thank you.
All right. All right. Again, folks, that's the first, third, and fifth Saturdays. What are we on this weekend? I think this may be the fourth Saturday coming up this weekend. This is the third.
But when my first visit,
That's what I'm looking at, sir, right now. And of course,
Ooh.
Microsoft calendar don't want to work on that screen, so let's see if it works on this one. There we go.
I'm
All right,
excited.
this coming Saturday is the fourth Saturday of the month, sir. Yeah, we're already past the third one. So your next visitation will be the okay, I'll tell you what I'm going to do, sir. Well, just in case it's drug test weekend or whatever, okay, the first visitation you'll have will be October the 4th from 1 o'clock to 5 o'clock at the mom's residence. All right.
Okay, no problem.
And then the next one after that will be the 18th. And then again, the 1st of November. And then there are actually 5 Saturdays in November. So you get that fifth one. Question, sir.
Okay, no, I just want to say when I'm over there, a crowd of people be over there. I just want to have time with my daughter.
His bill, man.
You know, mom's
Stop. I said one person each. That's part of the court order. Violation of a court order means I can put you in Bell County for 180. All right. So people follow my orders. So, sir, you can bring your son. That's the only one I want you to bring with you. Don't bring anybody else. Okay.
I'm gonna come by myself. Yeah.
You can come by yourself or you can bring your son with you. Ma'am, you can have one person there with you, but nobody else. Understood?
Understood.
Okay. I didn't think that was
I'm gonna
going to
take
be a problem.
pictures.
But okay. So this is his time and not their time. Thank you. All right, guys. Let's go ahead and I'm anticipating that we can get this one taken care of relatively fast because once the drug testing are done, it takes an hour. I mean, they're from Parker Heights in 3 to 5 days. So, Ms. Walker, did you have a date next month where Mr. Glass is going to be here? That's not the live enforcement dockets.
He will be here later in October 28th.
All right, that's fine.
Other than that, he will be on in-person dockets.
All right, October 28th will be fine. If he needs to, if he wants to move him for ahead of that, he can. But that'll give everybody, it'll give them a month to do what they need to do, and that'll definitely give Dad at least a couple of visits, and I'll see whether or not we're gonna move him up to the next level based on the circumstances. No drugs in the system, then ma'am, he's probably gonna move to the next level real fast, which means he gets to pick the child up for 4 hours and then bring her back.
Okay.
All right. All right, everybody, let's get this one set up and get it done. All right,
If
thank
you-
you. Anything else, Ms. Betzler?
No, I was just going to ask the parties to go back to the breakout room so I can finish the order.
All right, folks,
Okay.
let's go back to breakout and we'll let y'all take it from there, okay?
Okay.
See everybody
Thank you,
on
Your Honor.
October 28th, and I wish you all a
Thank
happy
you.
Halloween then, okay? Thank you.
Thank you.
Thank you.
All right. All right, we're off the record.
First, Your Honor, the state asked the court to take judicial notice of the original establishment order in this case, which is, or the latest one at least, child support review orders, suit affecting the parent-child relationship. It's marked as Exhibit A that was attached to our motion.
All right, the court's already taken, well, it's taken judicial notice of the entire packet. You may proceed.
And Your Honor, I believe Ms. Walker already sent a new findings review report up to you. State offers that new one into evidence, and we'll just label it as Exhibit C, Your Honor.
All right, Belinda's got to print that one out. It'll be a moment. Thank you. Then at this time, I have State C at this time, sir. Ma'am, I've got State C at this time. It shows what funds are still owed in child support and cash medical in this matter. And it appears that it goes all the way through the 22nd day of this month. I'm sorry, the 19th day of this month. Is there any legal reason I should not allow this in evidence at this time, ma'am, Ms. Davis?
No, no, sir.
All right, State One's admitted, State C is admitted.
Thank you, Your Honor. So essentially, Your Honor, as Mr. Davis is in arrears, $24,695.54 of child support arrears, $32,395.43 and medical support arrears, and you already took notice of the original support order. Therefore, the state asks the court to grant our qualified domestic relations order. I have that ready to be submitted to the court, Your Honor.
All right, Ms. Davis, I'm going to go ahead and grant this. He owes you a large sum of money, and the state's trying to get what they can for you, ma'am, on this to satisfy this status that is owed you. Do you have any questions about or anything else you're asking the court to do here today, ma'am?
Is there any way, I've sent like letters several times asking if they could like raise the amount that I get for child support, because he works full time and he's 100% disabled with the VA. So his income is like $9,000 a month and I get like $100 a week.
All right, ma'am, that again is not within my purview. That's the state is, I'm not sure what the state is aware of those circumstances. Mr. Welch, looks like the last order I have in this thing is how old at this point?
I mean, 2008, it looks like, Your Honor. I mean, is at least for the establishment order. I know there may have been some enforcement done prior to here, but Your Honor, the state can send Ms. Davis a review and adjust to see if, well, children are born in 2007 and 2008.
Yeah, so like 117, the youngest one is going to be 17 this year, right?
Yeah, he turned 17 in November and my daughter turned 18 a couple weeks ago. But I've sent in that review.
Stop. They both still in high school or one still in high school?
Both of them are still in high school.
When's the oldest graduate?
In June of next year.
And the younger?
He graduates May of next year.
Both of them graduate at the same time?
Yeah.
Okay, all right then. Man, technically you're still entitled to an adjustment, but I guess it's going to be a short term based on the service because it ends when they're either turn 18 or graduates from high school. So the one that's turning 18 this year, just turned 18, that would end next year when they graduate. And the one that's 17, that's going to turn 17 this year would end when she turns 18 next year. So, but you're still entitled to an update, ma'am, on that, so the state can see about doing that, all right?
Yes, sir. Thank you.
They'll send you the paperwork, ma'am, but get it back fast because, like I say, they're aging out fast on us. All right.
Yes, sir.
All right. Thank you. Anything else then at this time, ma'am?
No, sir.
Mr. Welch, anything else, sir?
No, Your Honor.
All right. Thank you both very much, ma'am. Good luck to you and the kids, and congratulations to everybody getting out of high school. But that's just step one. So everybody, don't get a job that AI is going to take their place in 2 years for. Okay.
Yeah. Will do.
All right. Thank you, ma'am. Good
Thank
luck.
you.
And we're off the record.
All right, Ms. Davis, you won't need to sign the order. It's already been taken care of by us. I'll send you a breakout room just to make sure your email's correct so that we can send you that documentation. And that's about it.
Okay.
So essentially, we're all in agreement, basically for the Clayton Homes Incorporated 401k retirement plan. The money from there, that Mr. Farr's account, to be used towards the child support arrearage. I believe Ms. Walker sent a new financial activity report,
I've got
uh,
it.
and the state will offer that and call it as a state's exhibit C into evidence.
All right, folks, both of y'all got your videos off for me, but at this time, I'm going to show you what the state's asking me to admit as C. It's the financial activity report in your case. It shows what funds are owed in child support and cash medical, with the ending date of this one being the 19th day of September. And as of the 19th day of September, $7,741.81 in child support is owed, and $982.80 in medical support are owed. Any objection to the court having this information as Exhibit C? Mr. Farrar?
No.
All
No.
right. Ms. McCoon?
No, sir.
All right, say C is admitted. Thank you.
Thank you, Your Honor. And the state asked the court to take judicial notice of the order attached to our motion, Exhibit A. It was already called or labeled Child Review Order establishing the parent-child relationship.
The court will take judicial notice of the entire court file, including the pleadings and the notice to the parties. You may proceed.
And so that's about it, Your Honor. We all agreed for that money in that account to be used towards the arrears.
All right, folks, Ms. McCune, Mr. Farrar, raise your right hands. Do you both solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, you're both officially on the oath. Confirm that with the testimony then, Mr. Welch, and we're good to go. Thank you.
Thank you, Your Honor. State calls Tierra McCoon. What is your full name?
Tierra Shanique McCowan.
All right, Ms. McCollum, do you agree to basically use the funds that are in Mr. Farr's Clayton Homes Incorporated 401k retirement plan to be used towards the arrearage in this case?
Yes, sir.
Do you have anything else you would like to tell the court?
No, sir.
Pass the witness.
All right, thank you very much, ma'am. I'll be back in just a moment. Call your next witness, please.
State calls Charles Farr. What is your full name?
Charles Yancey Brooks Farr.
All right. Do you agree for essentially the money that's in your Clayton Homes Incorporated 401k retirement plan to be used to pay off your arrearage?
Yes.
Do you have anything else you'd like to tell the court?
No, sir.
Pass the witness.
All right, folks, I'll go ahead and sign off on the order that allows your agreement to take place and have those funds that are available transferred to pay off of the unpaid child support and unpaid cash medical debts. Do you have any questions at this time, Mr. Farrar?
No, sir.
Ms. McCowan, any questions, ma'am?
No, sir.
All right, then, Mr. Welch, are both parties free to go, or you need them back in breakout?
Actually, I'll have them both break out, but not to sign the order because the order doesn't need their signature, just to get their contact information and other things, Your Honor.
All right, then the state's going to get you back and confirm your contact information and then forward me the order. Thank you, folks, very much, and we're off the record. Everybody be safe out there. Thank you.
Thank you, Your Honor.
The judge finalizes support, addresses unpaid balances, and ensures every dollar goes where it should, to the child. The courtroom eases as he ends with practical wisdom about accountability, responsibility, and life beyond the case. It's a rare moment of calm after chaos, a reminder that truth always finds its place. If you enjoyed this breakdown, make sure to hit that like button, subscribe to the channel, and we'll see you in the next video.